Can.
Call Rahui Katami.
Mr Chair, before I go on to part two of the bill, I just want to respond to some of the issues that have been raised. And one of those was from the Minister, who seems to think that because we are talking about the way that Māori are picked up by the police, that we are saying that that the police are being mean to Māori. In fact, that is not at all what I'm saying. What I am saying is that ethnic profiling exists. It has existed for a while, and our kids are the ones that are being picked up more by the police. Not regardless of whether they are doing anything wrong or not. All they have to be doing is walking down a road and the police are picking them up and taking them in for questioning. Not only that are they being picked up more often, they're also being charged more often.
Order. We're on part two, and part two is about identifying particulars, and I'll ask the member to come back to part two. Rahui Katami.
Thank you, Mr Chair. It is a fact that when we are talking about being discharged without conviction, that it is the judge's decision to make what those orders are going to be about. But because of this part, because of this amendment, now the police can also make the decision to hold on to their particulars. So regardless of whether they are now going to be convicted or not, they are going to have the police are going to be able to hold on to those particulars. So it is a matter of these kids being found guilty by the police, not by the judge, but by the police. Part two of the bill sets out the detail being recorded of how the identifying particulars of a person may be entered, recorded and stored on the police information recording system. And in section 34 subsection 2, authorising those same images to be destroyed depending on whether an outcome is reacted that does or does not authorise continued storage. The part, however, does not provide any detail about how the impressions of a person's fingerprints, palm prints or footprints will be destroyed. It does not specify how the photographs or visual images of a person are protected and how they are to be destroyed. All we learn is that the identifying particulars of a person that are obtained under Section 32 or 33 of the Policing Act are able to be entered, recorded and stored. What Section 32 says is that a constable may be able to use reasonable force that may be necessary to secure the person's identifying particulars. Of course, that could well open up another debate about how we define what reasonable force is and what sort of force one needs to retrieve a photograph or a set of fingerprints. Section 34 and 34A are woefully inadequate in providing details around the collection, utilisation and storage provisions. We know that there have been trust issues with the police holding such information, and there are concerns also from human rights advocates and civil liberties spokespersons around the whole issue of storage of personal data. And I think the anxiety around the storage of personal data is such that the bill should have addressed this. The public have a right to know what is going to happen to personal data that is stored, and also when the decision is made to discharge that data, how it will be destroyed. The explanatory note to the bill tries to give some sort of an explanation around storage. It tells us that the storage of youth IP is vital for the detection of youth offenders who go on to re-offend. Early identification of repeat youth offenders is important for ensuring that interventions are put in place to help prevent repeat youth offenders from progressing to the adult court system. It is also vital to solving crimes and providing satisfaction to victims of youth crime. But what is a defining characteristic of this bill is that these broad statements go nowhere. There is no detail about the types of interventions that might be put in place. We are told that fingerprints and photographs are vital for solving crimes, a fact that I would have thought was fairly self-evident. But we're also told that fingerprints and photographs provide satisfaction to victims of youth crimes. although it is hard to see exactly how that works either. But what we don't have, Mr Chair...
Rahul Katani.
Thank you, Mr Chair. What we don't have in any part or clause of this bill is the analysis and the policy justification that makes this bill necessary. So I want to leave the last word to Joseph Stafford, who wrote on Facebook this morning with this comment: if you're not convicted, then your details should be erased. Our Gen Z discharged without conviction? That's not convicted. Our Gen Z tweens are the most likely to infringe on society can't-dos because that is just how they are wired. Having got bored with the boundaries set for them at home, they now are testing society's boundaries outside the fence, trying to figure how much rope they have to play with. This is normal and what any actual community should absorb. It takes a village to raise a kid and a teen. I'm not advocating raving mayhem either by misdemeanour things like drinking in a public place, driving on a learner's licence and the like are all part of a teen's learning. Call it youthful exuberance, but there seems to be more lax behaviour expectations of white, middle-class company directors and their management of hundreds of millions of mum and dad investors' monies, which has a far more significant impact on our society. All these folks should be fingerprinted on suspicion they are going to commit fraud because the form book clearly shows they have a disposition to. This is a direct quote. This is what the public thinks of this bill. This is what we should have heard if it had gone to Select Committee. Because it didn't go to Select Committee, this is the only way the public can have their say on this bill. Mr Speaker, there are legitimate questions to be asked about this bill, which the Māori Party has tried to bring to the debate by sharing the views of our listening and viewing public. We believe it is important to have the debate, to enable people to engage with the issues, and most of all, when we come to the end of Part 2 of the bill, we come to the word outcomes. We want to see outcomes which focus on the potential of our rangatahi, which support our rangatahi to be leaders, not outcomes restricted to the storage of photographs and fingerprints.
The Honourable Leanne Dalzell.